Thank you, Mr. Speaker. It is very sad that the Select Committee didn't come back with a strong report rejecting this bill, and that the majority of the Select Committee didn't listen and take in the many representations from individual workers, as just been mentioned, unions, community organisations, all of whom were opposed to... Sure, there were some submissions in favour of the bill, but they were few and far between, and didn't, they made some good points, some of them, but the overwhelming feeling of submissions was against this bill, because it does take away fundamental union rights, and if you want to read the detail of that, you can read the Green and Labour Party minority report, which explains the problems with the bill. Now, just to go over these fundamental union rights that have been taken away, one of the most fundamental rights is the right of members of the union to talk to union officials in their workplace where they work. That is the question of union access. And the present system operates pretty well. We heard all these submissions and we questioned employers' representatives, and there wasn't really much evidence at all that there was any significant disruption in the workplace under the present system of union access, which does require that access to be at reasonable times and not overly disrupting of the workflow, etc., etc. There's very few complaints about the present system before this bill. And this bill does put unions at a big disadvantage. It's been indicated there were some improvements in terms of the delays, but unions can still be delayed up to a couple of days in terms of getting into a job site. And various union representatives explained to the Select Committee their practice in visiting work sites, and that a lot of them have got to cover a lot of work sites in a day. And you've got to be able to vary the work sites a bit. You arrive, you've got 10 work sites to cover in a day, say. You have to spend a bit more time at one work site because there's a bit of a health and safety problem. So you phone up the next work site and say, look, we're going to be...
members, including me.
I'm very sorry, sir. The union official would phone up the employer at the next work site and say, look, I was going to come around 8 o'clock, I've got to put that out till 10 o'clock, I've got a bit of a problem here. And there's that flexibility built into the system where, the employer will cooperate with sort of changing times and all the rest of it. Now, an employer who doesn't want the union to be on the job or wants to weaken the union will be able to put off that visit for a couple of days, muck around with the time and make it much more difficult for the union to operate. And as the previous speaker said, there might be very important immediate issues like health and safety issues that require attention, although the employer might say, well, it isn't a health and safety issue, and I've been in a situation like that myself, working in a motor factory at one point, and there was a problem of fumes coming into the trim manufacture section where we were making the seats. The employer didn't think there were really fumes coming in. We did. We were being affected, and we were taking some form of union action against that. But you can see there that there's not necessarily agreement between the employer and the union on whether there actually is a health and safety issue. So you've got to have a flexible system of union access. The next basic right that is undermined by this bill is the right to stay in your job, that is, stay in employment, and that is threatened by this 90-day provision being extended to all workers. And the basic thing about staying in a job is the right not to be dismissed without good cause, without a reason being given. And, if you can just sack people at will, as this bill provides, and not give them a reason within the first 90 days of their employment, they naturally feel very hurt, particularly if they don't think there's a good reason. They're just being picked on, they haven't had a fair go, and that, grievance carries on in the person's emotions and feelings and all the rest of it for a long time if they lose their job unjustly. And also, when you're subject to that 90-day provision, when workers are subject to that 90-day provision, they lose a sense of power. There's a feeling of powerlessness that, you're at the whim, your future for those 90 days is at the whim of the employer. And this affects particularly people who are coming in under this 90-day provision will often be the more powerless workers, marginalised workers who have been unemployed, who've found it more difficult to get a job, some younger people, etc. They're all already feeling powerless. They'll feel even more powerless under this provision. And the other thing, and it's not recognised by this Parliament sufficiently, is the effort sometimes people go to get a job. They go from one side of the world to the other, and migrants coming in, and they want, it's cost them a lot. They've shifted their family, or the family's been divided for a while, where the mother or the father goes ahead and gets the job, and the others come later. Or you've got workers who've been unemployed in Auckland. They're moving down to the Waikato or down to Wanganui or somewhere to get a job, or get a job on a farm, take their family there, set them up at a school, and then, 75 days later they just get sacked without any reason. In fact, there's, just received, I think it was today, a case of Cheryl and Bruce, who'd shifted to be a herd manager, one a herd manager, the other relief milker on a farm. They tried to defend a migrant worker who was working on the same farm, and the employer just sort of told them to get lost, you've lost your job, etc., etc. No reason in terms of their work or their politeness or anything else, just the employer in this case didn't want anyone to dissent on any matter, and then they had to sort of, they got all sorts of problems with their kids being at a local school, and that means they had to drive them 40 minutes each way to school each day because they had to shift out of the farm, and all the rest of all these problems are associated with this 90-day provision. And the idea that it's voluntary, that you don't have to agree to it, is a bit of a joke, particularly in a situation of growing unemployment. If you want a job, you've got to go into the 90-day provision in this bill. It also weakens unions in the sense that there'll be a section of the workforce on a particular job who are there for less than 90 days, who will feel reluctant to say anything, criticise anything that happens in the workplace for fear of being fair. They won't want to join the union, particularly if the union's in some contention with the employer, because then they'll be seen to be, perhaps people who might be a bit more standing up for their rights, a bit more stroppy than others, and the employer will tend to sort of send them down the road and want a more compliant person, and there's plenty of examples like that. The idea that there's more jobs available through this 90 days, that hasn't been proven either, and in fact you'll get a less efficient workforce because if employers can just hire someone for 90 days and get rid of them, then there'll be less training, they'll be treated as temporary labour, etc., etc. The other issues that the Green Party and Labour Party minority report deal with is the personal grievance situation, that people can get sacked and then reinstatement is not going to be a primary remedy. So if they want to get rid of a union delegate, they might say, we'll just kick them down the road, they won't be able to come back on the job. It might cost us a bit at the employment court, but we can intimidate the rest of the workforce by getting rid of the lead union delegate. That's the sort of thing that will happen if you don't reinstate people. And also the provision for good faith bargaining, that's undermined by this provision that allows the employers to swamp the workers with their side of the story when there's some contention, say over an employment contract, which is not then the union doesn't have the ability to get at all the shareholders to sort of swamp the shareholders with the workers' side in a employment dispute between unions and employers. So it's a very one-sided provision, that, and will undermine the good faith bargaining between employers and union, which is the heart of good unionism. So altogether, this is a very bad bill, and there were huge demonstrations around the country. I was at the one in Auckland, which thousands of people attended, along with Carol Beaumont, and the unions are actually more active now than they've been for many years, and it's been...
Order.